Hi everyone, I'm Paul Wallin of Wallin Klarich again. I welcome all our Facebook friends to this week's topic. Every single week we get people that call us because they're upset that they're being prosecuted for a crime that happened many years ago. And so I wanted to clarify for everyone, how does it work in California? How long does the prosecution have to bring a charge against you? Can they actually bring charges against you 10, 20 years after the crime allegedly occurred? That sure would seem unfair, wouldn't it? This is called the statute of limitations. There are laws in California, and you can go to wklaw.com and read all about it on our website. But I just wanted to summarize the importance of the statute of limitations. The reason we have the statute of limitations in California is because it is unfair to ask someone to face criminal charges where they may go to prison when a crime occurred or didn't occur 10, 20, or 30 years ago. And why is that? It's because, first of all, many witnesses that might help your defense might have died or moved away. You can't find them. Or critical evidence that you would have held and used in your defense is now gone. Does that sound fair? Of course not. So the law in California has thought about this, of course, for years and has laid out certain specific rules about when you can be prosecuted for a crime and when it's just too late. But before we get into the specifics of that, here is a call we get about 2 or 3 times a week. I was arrested for petty theft at Kohl's, say, and I was given a citation to come to court a month after the event. I went to court, just like it said, and there were no charges filed. So I thought the case was over. I then went to school, I got my college degree, and I really now was looking for a good job. So I sit down and I want a job at Google. So I interview with Google, and Google says to me, "I'm sorry, we can't hire you. You have a warrant for your arrest from 9 years ago." And you say, "What the? 9 years ago, I have a warrant for my arrest?" And in fact, that's true. And so you, of course, call our office and you say, "You got to get this charges dropped. It's the statute of limitations." And unfortunately, we check into your case and we have to tell you, no, the statute of limitations doesn't apply because the district attorney had 1 year to file charges against you. And even though they didn't file charges in the month between the time you were arrested and went to court, they subsequently filed charges 8 months later. And they tried to give you notice, but you moved to Oklahoma. That doesn't mean the statute of limitations can be used in your case as a defense because it's 1 year for all misdemeanors, or most of them, from the day the crime occurred until the day the prosecutor filed the charges. You moving out of state is no defense. So that's why in some cases the statute of limitations does not work. But when does it work? If you're accused of a misdemeanor crime, in most cases except for certain sex cases, the prosecution must file charges within 1 year from the day of the offense. So that example I gave you at Kohl's, if the prosecutor does not file charges for 1 year after the date of the offense, they can never file charges. Well, what about more serious cases? Well, first of all, anyone who's facing life imprisonment, if that's the punishment, there is no statute of limitations. And that's when you see on TV all these crazy shows, cold evidence, cold cases, when someone gets prosecuted 37 years ago for a murder and now they're 86, they can be prosecuted. And they could be sentenced to life in prison, which isn't going to be a lot of time for that 86-year-old, but it's still allowed to be prosecuted. Any crime facing life imprisonment, no statute of limitations. Felonies. If a felony is punishable by 8 years or more, there's a 6-year statute of limitations. 6 years from the day of the offense to the day the DA files. If it's a felony punished by less than 8 years, they have 3-year statute of limitations. And another critical thing is on many theft offenses, embezzlement. it's 3 years from the day that the prosecution knew or should have known about the crime. So if you commit embezzlement in 1996, but it's not uncovered for a long time, you can still be prosecuted in many of those cases years later. And a recent change in the law has led to some really crazy results. In sex offense cases, there is a recent law that says that if a person comes forth and says, when she was 6, she was molested by you, and now she's 51, and you are 80, if the police file charges against you within 1 year of when they got that report from that 50-year-old lady, you can be prosecuted if there's corroboration of any nature. So there has actually been cases where defendants have been convicted for sex offenses that occurred almost 50 years before. Now, some of you may say, well, good, I'm really happy because I hate sex offenders. But in reality, nobody knows that that person was really a sex offender. By the time he's 80 years old, he can hardly remember what he had for breakfast, let alone what happened 50 years ago to defend himself. So that's what makes the statute of limitations a very valuable tool that Wallin Klarich uses to get our clients' charges dismissed in many cases, but it doesn't apply in others. So if you ever have a question about this, 877-4-NO-JAIL, call us and we'll help you anytime, or go to wklaw.com. Have a great week. I hope this helped you and educated you in some way. Bye.